Very good evening, students. Good evening, everyone. Please confirm about the voice and the video. Okay, students. So, first of all, I welcome each one of you to my class on the mock test of UP PCSJ. Let's start with my brief introduction. My name is Sandeep Khatri. My areas of specializations are the constitutional law, criminal law, commercial law, family law, jurisprudence, and law of torts. Students, as you can see, I have mentioned the link of my profile, so make sure you follow that to get all the updates about my special classes and my plus courses. I've also shared the link of my Telegram channel where you can connect with me and ask your questions related to your judicial preparation. At last, I have mentioned my code, that is Khatri10, which you can use to get free access of all the special classes available on Unacademy app. So this was about me. I request everyone, please be attentive, and this is going to be interactive session. So what we are going to do today is that recently I have taken one session of a strategy session on UP Judiciary examination in my special class. So in that particular class, we have discussed that how one can prepare for UP Judicial Services examination. What was the last time cutoff? What was the syllabus? What was the recent amendments that has been done in the syllabus? We have discussed all those details. So I highly recommend you to please go through with that special class. Abhidosh Srivastav, link for that class. I will not be able to share the link here on the YouTube, but what you can do is you can you can message me here on my Telegram channel and I'll share the link. ठीक है जी. तो आप अपना मुझे मैसेज मेरे टेलीग्राम चैनल पे शेयर कर दीजिएगा, तो मैं वहां पे आपको लिंक शेयर कर दूंगा. ओके, बिकॉज राइट नाउ आई एम इन द मिडल ऑफ द क्लास. तो अभी मैं एग्जैक्ट वहां से जाकर और फिर कॉपी पेस्ट करने में बहुत ज़्यादा टाइम हमारा वेस्ट हो जाएगा. ठीक है, तो वो कंप्लीटली स्पेशल क्लास है, फ्री क्लास है, सो यू कैन वॉच दैट क्लास. ठीक है, उसमें हमने पूरी डिटेलिंग में बात की है. ठीक है, चलिए जी. ऑन दैट नोट, लेट्स स्टार्ट विद दिस क्लास. आज की क्लास में हम क्या करने वाले हैं? वी आर गोइंग टू हैव सम मिक्स एमसीक्यू, जो भी मेजर सब्जेक्ट्स हैं व्हेन इट कम्स टू यूपी पीसीएसजे, आईपीसी, एविडेंस, सीआरपीसी, सीपीसी, कॉन्स्टिट्यूशन, कॉन्ट्रैक्ट. तो वी आर गोइंग टू हैव MCQs of all these subjects. So let's start with the first question. Section 82 of IPC lays down the rule of wholly in capex, partially in capex, both A and B, D, either A or B. Kaushtav, first one to answer correctly. Yes, students, when it comes to section number 82, that deals with wholly in capex, which means it's an absolute provision where there are no exceptions. So if there is a child whose age is less than 7 years, then that child will not be liable for any punishment of any offense. Now, why is so? What is the reason behind that? The reason is again very simple, because if the age of the child is below 7 years, then there is no way that the child may generate mens rea, which is again one of the important essential for every crime. Yes, there are exceptions of mens rea, but still, when it comes to child, if they don't have, because they don't have the ability to generate menstruation. That is why we have section 82, which is in the form of absolute, and we can call that wholly incapax. So Kaushtav, Abhitosh, and Anjum, everyone's answer is correct. Moving towards the next question. Students, humble request, please do write question number, that is a numeric, like question number 2, and then whatever your answer is. The doctrine volenti non fit injuria is contained in which section? 87, 88, 89, or all of the above? Top 3 students to answer correctly. The first one is Anjum. Correct answer. And yes, students, when it comes to the application of this maxim, volenti non fit injuria, that applies in all these 3 sections, 87, 88, and 89. That is why the answer is going to be all of the above. So D is the correct answer. Very good evening, Netaji. The right of private defense is based on the natural instinct of. Choose the most appropriate answer. Self-preservation, self-respect, self-sufficiency, self-reliance. Top 3 students to answer correctly: Anjum, Amit, and Kaushtav. Yes, A is the correct answer, which is self-preservation. In Hindi, we call that jaan hai to jahan hai. Okay, so the basic idea behind the concept of right of private defense is self-preservation, that you should be able to protect yourself to the best of your efficiency. Now, I have a second question here as well. Which section defines the term private defense, or you can say which section defines the term right to private defense? Yes, please, if you can answer that in the comments. Which section defines the term right to private defense? Very good evening, Amit, Prashant, and everyone, those of you who have just joined. Okay. I have got 2 answers in relation to my question. The first one is from Amit Pandey, nowhere defined. Anjum and Kaushtav has answered 96. So students, please make it a point. Uh, uh, when it comes to the concept of right of private defense, this term has not been defined in Indian Penal Code. First thing. Now, second thing, what is section 96? 96 is basically that it's a general rule that nothing is an offense which is done while doing right of private defense. So that is 96. One more answer can be the most appropriate answer of this question can be that the first term, that the first statement, the term right to private defense has not been defined anywhere, and the second term, to understand the whole concept of private defense, one needs to go through from section 96 till 106, because when you read starting from section 96 to 106, you can have the whole picture that how the whole concept of right of private defense works. Okay, so 96 does not define right to private defense. Next one. Which of the following punishment cannot be awarded under the Indian Penal Code? Top 3 students to answer correctly: Anjum, Abhitosh, and Amit. Kaushtav and Prashant, everyone's answer is correct. That is C, transportation for life. Can you please specify any section number where this has been specifically written that that transportation for life cannot be awarded under IPC? Can you recall any section number, any specific section number to support your answer, which is C, transportation for life? Okay. Anything other than this, Amit? Perfectly correct answer, Anjum. See, first you need to answer that section 53 of the IPC deals with the kinds of punishments that are available. You will not find their transportation for life because that has been substituted with life imprisonment. And where it is written that the transportation for life has been substituted with life imprisonment, and the answer is section 53A. Next one. In which of the following case it was held that death sentence should be given in the rarest of rare cases? These all are basically landmark judgments. Top 3 students to answer correctly: Anjum, followed by Amit and Netaji. Everyone's answer is correct. Kaushtav. D, Bachchan Singh versus State of Punjab. So, first thing first, section 53 firstly says that death can be one of the punishment. Now, in which cases we are going to provide death? So, the answer is the theory which we are going to apply here is rarest of the rare cases. And this theory has been first time when it was discussed was Bachchan Singh versus State of Punjab, a landmark judgment. Can you give me some examples of rarest of the rare cases? That what kind of cases can be treated as rarest of the rare cases? Anyone? Some examples? Some examples from the cases you may pick up? You know, to answer these kind of a question, there is a trick. And that trick is just recall all the cases where capital punishment has been given. So whether it is Ajmal Kasab case, okay, whether that is Parliament attack case, okay, whether that is Nirbhaya rape case, okay, so they all will fall under rarest of the rare cases, okay. There is no exhaustive list of rarest of rare cases, students. Okay. Now we are going to discuss some of the questions from Indian Evidence Act. So according to section 65 of the Indian Evidence Act, the secondary evidence can be admitted in dash exceptional cases. So basically when you go through with section 65, the list has been given there. So in that particular list, how many numbers of cases that list basically have? So the number they are asking basically. First one to answer correctly, Anjum, followed by Amit and Netaji and Prashant. Everyone's answer is correct. That is 7 cases. So if you are preparing for mains as well, so make sure you can easily recall all the 7 points. So there are 7 circumstances where you can use secondary evidence as well. Okay, so there are basically when it comes to documentary evidence, sorry, when it comes to documentary evidence, that can be classified into 2 forms. One is primary evidence and secondary evidence. Primary evidence is the one which one needs to be preferred, but yes, in as per to section 65, these are the exceptional circumstances where you can actually prove your point with the help of secondary evidence as well. The defense of alibi is best because which one is the reason? Choose the most appropriate answer. Top three students to answer correctly. First one, Amit, followed by Kaushtav and Nitaji. Everyone's answer is correct. That is A. Yes, students, A is the correct answer. Okay. So if the accused was not there, where the deceased was murdered, he could not have murdered her. See, the basic thing is, suppose if I am sitting in front of you right now, so because of the obvious reasons, I cannot be present in the same time somewhere else, right? So physically, if I am present here only, I cannot be somewhere else. So that is the reason why alibi is considered as one of the best defense. Now I have one more question in association with this, and I want you to answer that. Section 11 is plea of alibi or plea of alibi? First option I am giving you A. Section 11 is plea of alibi, or second option, plea of alibi is one of the illustration of section 11. Which one will you choose, A or B? I'm repeating myself. A is section 11 is plea of alibi. Option number B, plea of alibi is one of the illustration of section 11 of Indian Evidence Act. So which one will you choose? Jitendra Sharma, you have written twins. If you can please explain that. Okay. Starting from Amit, everyone has chosen the second option, and that is the correct one, students. Plea of alibi is basically the illustration of section number 11. So section number 11 is your residuary clause. So if something is not relevant from section 5 to 55, that may be relevant under section 11. For example, plea of alibi. Plea of alibi is not relevant in any of the sections, but in section 11. Okay. Next one. The principles of section 44 Indian Evidence Act cannot be extended to which of the following? Kaushtav, your statement is correct but incomplete. Okay, this question was not that difficult. I have not received a single correct answer for this question. My God. Anyone wants to change their answer? I have not received the correct answer till now for question number 8. And yes, now we have the correct answer from Kirtika RJ. Students, A is the correct answer. And let me tell you why you have answered incorrectly. The reason is because you have not read the question properly. The principles of section 44. So basically, when it comes to section 40 till 44, it deals with relevant judgments. Indian Evidence Act cannot be extended. The question is cannot be extended. If you go with the language of section 44, that will be extended only in the case of fraud or collusion, not in the case of misrepresentation or undue influence. And that is why A is going to be the correct answer. Okay? Very good evening, Kirti. Yes, Costa. In the question, they are asking about cannot. Okay. So please do read the question carefully. Okay. Next one. Opinions of experts are relevant under section. Top three students to answer correctly. Anjum followed by Amit and Tilak. Everyone's answer is correct. Kirti, Koshta, Abhitosh. Okay. Maria, please do correct your answer. It's not 46, it's 45. Okay. So 45 is the correct answer. Now I have one more interesting question in front of you. Let's see who can answer this one. Students, when it comes to opinions, opinions are relevant only for the experts, or even in generally opinions are relevant. So option number A, opinion of experts only are relevant. Second, generally opinion of everyone is relevant. Which one is going to be your answer, A or B? Okay, Abhitosh, I am going to take some classes for UP local law as well, so don't worry about that. Okay, I have already received a lot of requests in regarding that. So once the notification is out, we are going to plan the schedule. Okay, so make sure you are connected with me on my Telegram channel, and I'll update there. Okay. Now coming to the answer of the question. Okay, everyone is saying A. Starting from Amit, everyone's answer is only expert. Maria and Prashant, why you are writing 46 by the way? Do I need to cross check this? Yes, Prashant and Maria, waiting for your comments. Why you are writing section 46? See, the correct answer for this is 45 only. Okay. At 44, relevant judgments and an opinion of experts started from 45. Okay. Next. Oral evidence under section 60 of Evidence Act may be. Top three students to answer correctly. Amit, followed by Kirti and Anjum. Netaji, please do correct your answer. Megha, correct. Prashant, correct. Kaustav, please do correct your answer. When you read section 60 of Indian Evidence Act, that clearly states that oral evidence must be direct. Okay, so A is the correct answer. Okay, next one. Attachment of property of person absconding is mentioned in which section of CRPC? Now we are entered into CRPC. Costa, there is a simple reasoning in relation to that. Now let's take a practical example. Now suppose if right now I shared a story with you, Costa, that I have seen a murder this morning. This is just an example, by the way, right? Okay. So in case if I told you the whole story, I was just going for a morning walk and I saw that Mr. A shot down Mr. B. Okay, and Mr. B is killed now, and I'm the one eyewitness. But now, if I have given you all the information, at this point of time, at this time, this all these acts has taken place. Now the question is, can you go to the police and say that you are also a witness of that offense? And the answer is no. Because whatever you have, that is all hearsay information. And now let me tell you the exact reasoning why hearsay evidence is no evidence. The reason is very simple. When it comes to examination in chief, you can easily pass that, whatever information I have given to you. But when it comes to cross examination, you cannot pass the cross examination on the basis of hearsay evidence. Okay, now let's take an example. If in the cross examination they are asking to you that what color of shirt A was wearing, so this is that kind of an information which I have not shared with you, so you will not able to answer. So basically whatever your answer is completely based on information that is shared by me. So because of that, as per to section 60, the information, the evidence must be direct. Yes, there are some exceptions of hearsay evidence. For example, section number 6, for example, section number 32, clause 1. There are exceptions when even hearsay evidence may also be considered. But in a general sense, evidence must be direct. Okay. Now coming to the next question. Yes, attachment of property. Direct question. Anjum, Maria, and Amit, top 3 students to answer correctly. Yes, B is the correct answer. That is section number 83. Yes, Surabhi, completely correct. Chances of distortion are there also there. Next, section 84 of CRPC deals with top 3 students to answer correctly. Anjum, followed by Kirtika and Tilak. Yes, D is the correct answer. Direct question, section based. Everyone's answer is correct. I don't think this needs any more explanation. Complaints to magistrates contained in which chapter? Complaints to magistrates contained in which chapter? There are many, there are many relevant questions attached to this one. You must know the section numbers as well, of the complaint proceeding. Top 3 students to answer correctly: Anjum, Maria, and Netaji. And everyone's answer is correct. That is C, chapter number 15th. Okay, tell me the section number of complaint proceedings. Tell me the section number where the term complaint has been defined. Kirti, completely correct answer from section 200 to 203. From section 200 to 203 deals with complaint proceeding. And section 2D defines the term complaint. Complaint made to police officer or to the magistrate? Okay, I hope everyone can easily answer that complaint will be made to magistrate. In the question itself, it has been written complaint to magistrate. So my question is, which magistrate we are talking about here? Which magistrate we are talking about when it comes to complaint to magistrate? Judicial magistrate second class, first class, chief judicial magistrate. Which magistrate we are talking about when it comes to complaint proceedings? So when it comes to section 200, in front of which magistrate you may go? Judicial magistrate, completely fine. But judicial magistrate, which judicial magistrate? Judicial magistrate first class, second class. If you are answering first class, can you please give me the reasoning? If you are answering that because the answer is judicial magistrate first class, can you please give me the reasoning? Aman, you have written CJM. Can you please give me the reasoning? I have not received the correct answer till now. Come on. You should be able to recall the language of section 200. Any magistrate who may take cognizance. Okay? Any magistrate who may take the cognizance. That is the reasoning which you should know before answering judicial magistrate first class. Okay? Next. Appearance by public prosecutor comes under who will appear on the behalf of the state, who will present the case of the victim on behalf of the state, that is the public prosecutor. Under which section? Top 3 students to answer correctly. Kirti, followed by Aman. Abhitosh 310 पे कहाँ पहुँच गए आप? Tilak, correct answer. The correct answer is 301, section 301. Okay, I have one interesting question in relation to this. So suppose if the victim comes from, okay, listen the question carefully. If the victim comes from a rich family and they can afford one of the best advocates available in this country, in that case, is there any exception that their case may be represented by the advocate of their own choice? Please answer in the comments. Yes, Maria, you may please go on with your doubt. You may write your question in the comments. Abhitosh, yes, they can. Amit, no. What about others? I have asked a very relevant question, a simple question. Aman, but under the direction of public prosecutor. He will assist with court's permission. Veteran advocate may assist PP. Okay. Wonderful. Okay, now let me conclude this, students. See, your answer is completely correct. Yes, public prosecutor only under section 301 will represent the case on behalf of the victim and will represent the state. When it comes to private advocates, if the family of the victim or the victim may afford one of the best advocates, that advocate may assist the public prosecutors. But again, the case will be represented by public prosecutors only. Okay, so there are basically no such exceptions. Which section of the CRPC deals with when police may arrest without warrant? Maria, answer to your question. See, that is completely your personal call. If you think, uh, see, first of all, it is very personal call, Maria, that whether you still want to go with UP Judiciary or not. Okay. My advice would be, if you think there are any kind of doubts in your mind that you are not done with the syllabus of UP Judiciary, you better focus on the mains examination of UP APO. Okay, but if you think that you can pull it off, then best of luck and you can appear for the both the examinations. Okay, but see, one thing is, as of now the notification of UP Judiciary is not out. Okay, yes, there are 99.9% chances, as far as the rumors and as far as the information that has been shared in the newspapers, that the notification will be out anytime soon, maybe in this month, the last week only, or maximum by the first week of December. But your first preference should be your mains examination, and after that you can, I think, easily prepare for the PT examination for judiciary if you want to. Okay, so yes, the answer is B, section number 41. Okay, I have one counter question in this. Section 41 clause 1 or section 41 clause 2? Which one? If you are answering B, then please do clarify. You are talking about section 41 clause 1 or section 41 clause 2? Everyone's answer is correct. That is section 41 clause 1. Now we have entered into the Contract Act MCQs. An agreement was entered into with the minor. This is agreement. This is dash agreement. Which one? Top 3 students to answer correctly. And that is A. Everyone's answer is correct. That is void ab initio. A is the correct answer. Consent is said to be free when it is not caused by. Top 3 students to answer correctly: Kirti, Jitendra, Anjum. Okay. Kaushtav, please do correct your answer. B is the correct one. That is in the case of undue influence. Okay. So undue influence is the correct answer. If the event becomes impossible, such contracts becomes. And everyone's answer is correct. That is C. The contract becomes void. Jitendra, please do correct your answer. The correct answer is C, not D. An agreement to do impossible act in itself is. Top three students to answer correctly: Kirti, Amit, and Anjum. B is the correct answer. That is, an agreement to do impossible act is itself void agreement. In which of the following circumstances the original contract needs not to be performed? Top three students to answer correctly: Kirti, Aman, and Amit. And everyone's answer is correct. That is D. Correct answer, Kirti. This is because of section number 62, which you call novation as well. So that contract needs to not to be performed. In case of alter, substitute, and resign. Okay. Can you please answer what is the difference between alter and substitute? Okay, alter and addition. What is the difference between alter and addition in a contract? My question is, what is the difference between alter and addition? Cost of alter and addition. Alter means changing the nature. Alter means change in the terms. Addition means put some additional clauses in the contract. Okay. Now, these are some questions from the Constitution of India. Which fundamental right cannot be suspended even during an emergency? Correct answer, Amit. Kirti, correct answer. Top three students to answer question correctly. Question number 21. Kirti, Anjum, Kaustav, you have not written the answer. You have written only the question number. Okay, yes. Everyone's answer is correct. That is right to life and personal liberty. Which of the following are fundamental duties? Safeguarding public property, protecting the sovereignty, integrity, and unity of India, developing scientific temper, and humanism. Okay, Kaustav. Amit, Anjum, and Jitendra, top three students to answer correctly. These all are the basically fundamental duties. All three. Which of the following articles of Indian Constitution contain the right to religious freedom? Top three students to answer correctly. Kirti, Aman, and Amit. Jitendra Sharma, please do correct yourself. Article 25 to 28 deals with the right to religious freedom. So A is the correct answer. Which of the following is correct with respect to right against exploitation? And everyone's answer is correct, starting from Kaushtav, Subhadra, and Kirti. A is the correct answer. That is prohibition of traffic in human beings and forced labor. The fundamental duties were included in the Constitution of India by which of the following Amendment Act? Everyone's answer is correct, starting from Kirti. That is D. 42nd Amendment is basically responsible for the introduction of fundamental duties. Now, these are some questions from the CPC. In case of res sub judice under section 10, the court can. Yes, 42nd Amendment is also known as the mini constitution. One of the biggest amendment in the history of Constitution of India. Starting from Amit, Preeti, and Kaushtav, everyone's answer is correct. That is D. Students, when it comes to res sub judice, pass interim orders, grant injunction, appoint a receiver. These all are the exceptions of res sub judice. So the correct answer is D. The rule of res sub judice under section 10 of CPC. Choose the most appropriate option. This question was not that difficult. Student, the question is the rule of res sub judice under section 10 of CPC stays the previous suit. No, it stays the subsequent suit. B is the correct answer. Aman only student to answer this correctly. Okay. Rule of res sub judice will not stay the previous suit. The rule of res sub judice will not stay the institution of subsequent suit. Okay. So the correct answer is B. Which of the following term means under consideration of a court of law? Top three students to answer correctly. Uh, Kirti, Preeti, and Amit. Aman, please do correct your answer. Sine qua non is the maxim which means the most, the most essential, the most important essential is called sine qua non. So when it comes to under consideration of a court of law, we are basically talking about sub judice. The matter is sub judice. When we say the matter is sub judice means it is pending in the court of law. It is under consideration of a court of law. Which of the following suit is not of civil nature? Top three students to answer correctly: Kanika, Preeti, and Amit. And yes, everyone's answer is correct. That is D, suit relating to political question. Okay. Whether courts can, without exception, try all suits of civil nature, which means the courts can try all suits of civil nature absolutely. There are no such exceptions. Choose the most appropriate answer. Top three students to answer correctly: Kanika, Amit, and Preeti. Top three students to answer: Kaushtav and Kirti. Correct answer, that is C, no. You cannot try suits of all civil nature. There are exceptions. There are some suits which are barred by law. General power to transfer suit under section 24 has been granted to which court? Top three students to answer correctly: Kanika. Correct answer. Kirti, please do correct your answer. Preeti, please do correct your answer. Kaushtav, C is the correct answer. Both High Court and the District Court have the general power to transfer suit under section 24. Okay, I think there are mistakes in this question. Let's avoid that. The options are wrong. Which one of the following is a landmark judgment of civil nature? Preeti, Kanika, and Kaushtav. Everyone's answer is correct. The landmark judgment is of Dhulabhai versus State of MP. Section 11 is based on the maxim Top 3 students to answer correctly: Kanika, Preeti, and Amit. No, Amit, your answer is incorrect. It's B. Interest Republicae ut sit finis litium, which means in interest of the state is in finishing the litigation. So B is the correct answer. Okay. Yes. Now anything which you are not clear with, you may ask questions. Yes, please. Any question, any problem? You're welcome, Kanika. Anyone else having any question? If not, quickly give me a thumbs up. I'll wrap up the session. So this is basically the link of my profile, students. If you do like my classes, please make sure that you share the link of my profile with your friends who are preparing for judicial services. This is the link of my Telegram channel where you can connect with me. And at last, I have mentioned this code that is Khatri10, which you can use to get free access of all the special classes available on Unacademy app, and also to get 10% discount in all your plus courses. Student, this is one important information that the judiciary test series for December is now available. That for the free subscriptions also there are tests that is going to be offered, 4 tests per month and 4 tests per month for the current affairs and GK and the major laws. For plus students, this is the list, and for iconic, this is the list. Done. This is the judiciary test series for December. As you can see, this is the batch which is going to be started recently, Sarthi 4.0 comprehensive batch for judiciary by all the respective faculties. This is the batch which has been recently started for Rajasthan State Judiciary batch from 18th of November. This is the result from Unacademy for the Rajasthan Judicial Services exam. These are the features of Unacademy Iconic. And this is the YouTube and the Telegram channel of Unacademy. And that's it from my end. Kaustav, I will share the details of special classes soon in on my Telegram channel. Okay. Yes, Aman, these kind of session will be conducted on a daily basis. On a daily basis, like tomorrow as well for the today is 24th of November. So you can expect this YouTube class on a daily basis till the end of November. Okay, 30th November. Till 30th November, the class is going to be take place in the continents. Daily basis. Done. You all are welcome. Thank you for the kind comments. On that note, thank you very much. See you in my next class. Till then, yes, it's time to say peace.